in as much as experience is the best teacher, we do not personally have to experience everything in order not to fail. Because with experience comes, testing the waters, being able to know, you're uncertain whether you will succeed at every point in time. But if you are able to tap into the experience of others, learn a bit about what other people have been through, learn a bit about how people feel maybe they have failed in their endeavor, then you could limit your own challenges. You could be able to meet your own challenges on a better platform. So Metalex is practically offering you a platform with which you could learn from the experience of others. So I think that's what we are doing here. So they have presented a wide range of topics. I'm sure they are displayed on your screens right now that we will be talking about. I think there are about 7. So within this period, we will try to discuss these different areas as it pertains to our profession. I believe all of you are lawyers here. And then at the end of which we would be taking questions. There will be a questions and answer session. So like we all know, the legal profession has expanded its tentacles to so many areas of life that you can earn a living practically from anything, any angle of life now, be it tech, sports law, litigation is just an aspect of it. Then you can specialize in corporate or international law. You could delve into the public interest area. I personally believe that one does not need to be limited, but you also have to know that you need to also specialize in a particular area, so that if you create a niche for yourself in a particular area, everybody would be forced to come towards, they will be drawn towards you because you are the person that can render services in this particular area, and they will have no other option than to say, oh, we need a tech lawyer. Ella is the best in this angle. We need a sports lawyer. Allow is the best in this angle. And then everybody within your circle and maybe outside your circle would be forced to come to you. So what I'm saying in essence is there is need for you to identify a particular area of law from the get-go. Identify a particular area of law, because when you are starting out, there will likely be that confusion, which area do I delve into? And there's need for you to make some money too. So you'll be like, which area am I going into? If you stick to one area, will I be able to survive just by, concentrating on this area? But the legal profession, I'm sure most of you have read now, it may not be immediately lucrative, but if you plan well, you will definitely get to where those top guys, I know you guys know some of these top shots in the legal profession, you definitely get to that particular point where they are now. So there is need, as you're starting out, for you to choose a particular area that you want to delve into. And then in order for you to do this, there's also need for you to gather some additional qualification. Now, why I'm actually mentioning this is because when one is starting out as a young lawyer, there are certain qualifications, certain trainings that are offered to you on a platter of gold. I think I missed some of those opportunities. Like you'll be told to come, maybe attend programs so that you can become a chartered arbitrator and all that. It could be cheaper for you now, and you would have the time and space before money begins to occupy your mind so much that you will not be able to concentrate on these things as much as possible. So it is best now that you take it up at this point in time. So the challenges and rewards of the legal profession, of course, I'm sure every lawyer would tell you that the legal profession is actually very challenging. There is the problem of juniors not being able to see the reward, except maybe you are working in some of these top class, top tier, tier A firms, maybe some of them in Lagos, like the guys in Templars or no other law firms. But if you've not had the opportunity of working in those law firms, you would have the problem of being immediately discouraged by the financial aspect of it. I know money is never enough, but it could be very discouraging. But the truth is, you must hold on. I think that's the major challenge most juniors have. The challenge or the immediate discouragement that comes with not being able to hammer, to make it as you would have loved to make it immediately. But I think it's best to just hold on and then put in the hard work. With time, it pays. Some of us are still putting in the hard work, and we are still hoping that you will improve from level to level. So with time, everything balances. Now, there's one thing I wanted to point out before we proceed when we're talking about the challenges and rewards. Now, I for one, believe that the number one mistake we make as young lawyers, the inability to choose a career path and the inability to choose the right firm that we want to work with. Sometimes we just work with a firm merely because we want to work and earn money at the moment. Now, if you make that mistake, just work with a firm just because you want to earn money, you discover that you will not be able to learn anything that will be advantageous to you with respect to the career path you've chosen or the area or specialty you've chosen. You'll not be able to learn much. You'll not be able to also get out of that particular firm in time to be able to build a career elsewhere. So you will be doing something majorly disadvantageous to yourself by just, jumping into a firm just because you're tired of waiting, you're tired of searching, you just want to jump in and make money and then maybe come out and pursue what is really in your mind. But it doesn't always work like that. So that's one of the major practical challenges that I personally had. And I think it's good I shared with you. Back then in Makurdi, I knew at a particular point it was necessary for me to leave. But I couldn't take the bold step because, the money was not enough, the finances was not enough. But I knew it was time for me to get to Abuja and then, face my corporate practice head on. But because I wanted to stay here and learn first, and then after some time, I needed something bigger, but I couldn't transition from here to there. That's one of the things you have to look out for. And then and get the additional qualification. It's actually very necessary. Networking and relationship. Networking and relationships. The legal profession, no matter which career path you choose, the legal profession thrives on networking. You actually would be able to succeed with the number of persons the number and the quality of persons you've been able to network with. So it is very necessary that as you're starting out, you immediately start joining several associations, be as social as possible. If you don't meet people and if you don't interact with people, you never get to know what's their problem. And you have to be sure that as you're meeting people and they ask you some questions you feel may not even be important, you may feel that the question has to be very difficult, worthy of a lawyer explaining before you can answer in a very diligent way. But you need to be very professional with these people when you meet them. You never know who is rich and who is broke. Somebody that is maybe seemingly not very liquid today, tomorrow, that person may be actually very, very liquid. And that's a person that could take you from a particular level to another level. So when you meet people, speak with them professionally, and then try as much as possible to take any question anybody asks you. The law, what is this one? It may look like an innocent question. Maybe they're trying to pull your legs, but give your honest opinion about it. Be as precise as possible, be as cautious as possible, because that one question could maybe entice this person so much that it would give you something very big to do for them. So you never can tell where these things will come from. So you have to just handle relationship very well. Because if you don't socialize with several groups, if you don't put yourself out there, like people would say, if you don't put yourself out there, nobody gets to know you. If you don't answer these simple questions, nobody gets to ask you the hard questions. So it is from answering some, seemingly simple questions that people get to ask you some very good and interesting questions. The more you answer them, the more you grow. So you have to choose a set. There are a set of persons we all grow with. They could be friends, they could be colleagues from school. So you have to maintain a particular circle around you because people grow together, and these are the same persons you would be able to handle their life, all their legal issues in the nearest future. So if you choose a particular set of persons to grow with, it is always better because you get to know them, you get to study them, and then along the line, this set of persons, they give you everything, all their legal works to do. First, it comes from there before you even get them to advertise you outside. If you do one work for Mr. A, Mr. A tells Mr. B, this is the lawyer that did this for me. That's another way of gathering clientele. I know we are in the tech era, so you can leverage on the tech space to actually get clients. The legal profession would say you're not supposed to advertise. I think we are seemingly putting ourselves out there in the internet by, writing about the legal profession, discussing various areas of law. This way, we garner relationship and then we network with so many other persons. So the essential skills that you need as a lawyer. Now, if you happen to want to be in legal practice, some people feel maybe legal practice is all about going to court and speaking in court. It's not only advocacy. The core of legal practice, especially with the front-loading era now, the core of legal practice is legal research. It is legal research. Now, every case is won or lost in the office. So if you don't do your research well, you will end up losing that case. Because no matter the abracadabra or no matter what you go to court to speak on, without the solid backing, without solid and grounded knowledge in the law, you won't be able to, impress anybody by just speaking English. So you need to know how to conduct legal research, arm yourself. Actually, now there are a lot of, they have made it very simple for us to do research with the Law Pavilion, with the Nigerian Weekly Law Report, and then there are a lot of books online. There are a whole lot of books online that could help your research. I think as we're going, we'll discuss this in details, but I could just mention them. If you're going to be a good draftsman, because it's expected of juniors to learn how to research and how to draft. And there are some books you can read that would help you to draft properly. Now, starting from very simple letters. Letters to a lawyer is the biggest form of advert. Your letter, your briefs, because you never know what the client would do. A client would basically take your brief and then give it to another person to proofread and review. So you'll be embarrassed by saying that the work you haphazardly had done would now be subjected to thorough scrutiny by another person. In fact, they could go to lengths of even paying another person to scrutinize your own papers. So you are as good as the paper you put out. So anytime you put pen to paper, just know that you are advertising yourself. So it is very necessary that you read some solid books, some good books on drafting, so that you would be able to communicate your points in very precise language. Lawyers have the tendency to let their ego reflect on their drafting, but it's not good draftsmanship. You have to be as precise as possible in drafting. The simple and formal language is what, and your ability to communicate your point in as simple and concise way as possible is a skill in itself. Most people don't have it. That's why they end up drafting. Maybe you want to tell somebody that you've not done this. Instead of just writing one sentence, you've not done this, they begin to, cut through the corners, move from point A to point B, and then from point B to C before they now arrive at D. So it is very necessary that we get to read books. There are good books on drafting, whether it is contract, whether it is just drafting court briefs. I could mention a few of them. If it's contract, you have to get yourself acquainted with the Encyclopedia of Forms and Precedents. You have to get yourself acquainted with the Kelly's Draftsman. And then you have to, for court briefs and drafting claims, if you get in contact with Boolean and Leak, it would really help you know that drafting is not all about speaking grammar. Drafting is about being concise and precise. And then there is the need for you to master the act of manipulation of fact. Because no matter what you do, you can research the law. Everybody knows the law. At least everybody knows where to find the law. Everybody can apply the law to fact, but not everybody can analyze fact to make it possible for law to be applied to it. So a client will come to you with a story that is not as good as you would think it should be. The moment you are able to sit down and then manipulate this fact, you will now be able to know, okay, this is where this fact pertains to, and this is what this man is actually talking about. So when you are able to know how to manipulate these facts and then apply them to the law, that is where you would now be a true professional. So next slide, please. When it comes to the ethics and professionalism, we've all had, I'm sure we've all come in contact with the rules of professional conduct, and then we've all come in contact with the Legal Practitioners Act. The rules of professional conduct, I think it has been recently amended. We have the rules of professional conduct 2023. They have amended it. So the ethics of our profession is majorly codified in these two sets of laws and rules. The rules of professional conduct lays down in details the manner which we are supposed to operate. It lays them down for us, and we cannot get out of it. Because if you breach these rules, it comes with its own consequences. So we have a duty to the court. Of course, I'm sure when we're in law school, we all delved into that. We all read that. We all studied that. So we have a duty to the court, a primary duty to the court to make sure we aid the cause of justice. Then we have a duty to the society. And then we also have our duty to our professional colleagues. Okay. Now, there is the need, even though you are defending your client, you have to also pay attention to these duties that you owe to these three set of persons: the duty to the court and the society, the duty to professional colleagues, and then your duty to your client himself. And then one major aspect of it that comes to play every time is the conflict of interest issue. Ethical dilemmas, conflict of interest. So when you come out, maybe in your quest for money, you may meet clients. But then if their interests are conflicting, if you know that Mr. A approaches you, let's say Mr. A approaches you to do something for him, and then along the line, Mr. B also approaches you. So if you're defending Mr. A, you of course cannot also defend Mr. B. Except even though Mr. A and B had issues before, but this issue that Mr. B is bringing to you does not concern the issue you're handling for Mr. A. okay, we can find a common ground there, and then you can sort yourself out. But there is the problem of conflict of interest. So you have to be sure that at all possible time, at every time, you have to watch out for conflict of interest. You cannot allow yourself perform a duty for a client and then it conflicts with what you've already accepted to do with for another client. So that is where you can now reject briefs. You can say practically, I cannot do this one because I'm already handling this for Mr. A. It happens mostly when it comes to companies. The company can get a brief for you, and then Mr. B, let's say somebody brings a case. There are two shareholders in a company. So these shareholders have competing interests. And then Mr. A is telling you, I want to push Mr. B out. And then Mr. B had been an existing client. So you cannot take Mr. A's brief in that angle. Then we have a duty to act honestly at all possible time. You have to be honest no matter what. What is not possible, please do not tell a client. If something is not possible, just be honest about it. It always pays. Because if you tell a client that you can manufacture results that is practically not possible, then at the end of the day, you would have ended up embarrassing both yourself and the profession. So it is best that you be honest at all possible time with the client. Be very honest with clients. Tell them what is possible and what is not possible. Okay. Now, there's also the duty of confidentiality. I think there are a lot of cases now that you should look out for. There is this current trend where client account and the earnings of lawyers are coming under thorough scrutiny by the EFCC because of the Money Laundering Act of 2022 and subsequent regulations made thereunder. So perhaps you may want to read the recent decision in Abuareme versus CBN and others. Abuareme and CBN and others. It's an ongoing issue. It was decided earlier on, but the Money Laundering Act, the amendment done in 2022, has brought another conflict, which I believe it will be worthwhile for you to read, because if these cases succeed, then we would have to be careful with the money that we take in to our account, because our confidentiality, the duty of confidentiality, which protects us from divulging information to clients, would have been breached. It would have been properly tempered with, and we would not have that solid background. But you have to note, there were other decisions before then. In fact, when you read the judgment, you would know. So the earnings of lawyers is coming under scrutiny at the moment as we speak. So that confidentiality that has always backed us, a lawyer's money is his money, no matter where it is taken from. It's supposed to just be your earning. Now it is coming under serious attacks. So we need to keep ourselves abreast with that. Just follow that case. Just follow the development in that case so that you also get yourself protected. This whole SCUMEL and everything, they are trying to get it to affect lawyers now. So though that decision has said that you cannot question the earning of lawyers, you cannot question whatsoever he has gotten, but it is going on appeal. I'm very sure it is going on appeal, and we will have to wait to see what the Court of Appeal says again, because the Court of Appeal has already decided in the NBA versus, I think, one NBA case. Okay, so we have to make sure that we, at all times, like I earlier said, observe the rules of our profession. Familiarize yourself with the rules. It is very important. How do you treat? Because it always looks as if these rules won't apply. But I give you an instance where it could actually lead to problems. Now, if a client hires a lawyer and then eventually he wants to change that lawyer. Now, some people just feel it is okay to just go and file a notice of change of counsel, okay, in line with the rules of court. But that is not enough. It is not enough because the rules of professional conduct has laid down several steps to follow. As a lawyer, your duty as a lawyer to your fellow colleague. So you have to serve a letter notifying the other lawyer. You have to tell him to get, discuss with him as to whether he has been paid or not. And then you guys have to settle this before you even get to file that notice of change of counsel. Or if you filed already, you have to also agree with him, because it is possible that somebody may want to take you up with it and they may go to the LPDC. It could become an issue. It could actually become an issue. I've seen it play out severally. So while there is counsel on record, you have to, that's just one instance of, the RPC becoming a very important issue while you are litigating a matter. So if you pay attention to the RPC, I repeat, it is very necessary that we study the RPC because it is the template on which the legal profession revolves. If you don't understand the RPC, there is the likelihood that you are going to make mistakes that will be very costly, because you never can tell when a lawyer on the opposing side is going to be willing enough to take you up with it. So we need to be very careful with that. Okay, let's go on to the next one. Okay, so we have the building a strong foundation for legal research and writing. I have already mentioned that every draft work to a lawyer, every draft work is an advertisement. You would say, my senior would review it, but the review work, to review a work simply means, you are going to put it right, okay? But the thought in your mind and the way you've presented it would make the review better. This is what I mean. If you're given a work to do, maybe in the office, a research work to do, the limit of your research, because a senior may not really want to also do another research based on what you've done already. He may just want to quickly review the work so that it could be filed. He won't want to go through the stress of reading all the authorities over and over again, maybe reading your work line by line. But if you are going to be the one signing a document, it is very necessary that you consult books. You cannot depend on your knowledge of the law alone at every time. You just believe that you can use your mind and just put it down and it works. No. It is necessary that you consult books before you draft. It is necessary that you read authorities. And I kid you not, there are authorities on almost everything. There's nothing really new. There's nothing really new that has not been decided on. There must have been something the court has said about a particular point of law at every time. So as juniors, we are often tested. The first test that comes to us is for us to research. That's the first thing. So you need to familiarize yourself with the court rules. And then when you familiarize yourself with the court rules, you familiarize yourself with several authorities. Like our office, we are made to report, I think, at least 2 cases every day. It is necessary. It looks stressful, but by the time you begin to read judgment and then you begin to study the words of some of these erudite judges, and then you absorb them, you will then be able to put this thing on paper and they will look different, because the idea is to not just write, we submit. The idea is to be able to break down facts. It's called factual analysis. The facts are the fact. You cannot manufacture the fact, but you can manipulate the fact. You can manipulate the fact to bring it out in a way that you can present it to favor your case. And you can manipulate the fact and then get it wrong, and it does not, you have the correct set of facts, but you cannot now apply the law to those facts. Okay. So I had mentioned a couple of books I think you should consult in your, while preparing to draft. In fact, before you even put pen to paper, you consult these books. They are very good. If you're drafting a claim for someone, it's necessary that you consult Bullion and Leak. It was introduced to me by my principal, and I think the book is actually very, very good. It's a good book. Then you can consult Kelly's Draftsman. I know we all know these books, but I'm just saying it is necessary for you to read these books. It is necessary for you to use the templates from these books in your legal research. You can try as much as possible to at least read one case, even if you don't want to. You don't want to really get it into your head. Just read it. It operates on your subconscious. The moment you pick pen and you want to write something, it just comes back to you that you read this before. So what you're actually about to write could be wrong. What you're about to write could be right. So, and then you have to be as clear and concise as possible. Okay. Be as clear and concise as possible. There's no need for you to try to overdo yourself. Get the grammar to be as bogus as possible. Actually, simple writing conveys the message better. Simple and decent letter writing, they just convey the message and in a language that everybody can understand. So you may forget about the embellishment and the flowery thing. Just write. It's always good. Okay, the next slide. Okay, so the structure and organization of legal drafting. Now, I know we've all, let's say it's a final written address. If you're working on a final written address or a brief, we all know that there will be that introduction and then a brief statement of fact. Now, in a final written address, you already have the idea of the cause of action. Let's say you were the plaintiff. Let's say you are the plaintiff. Okay. So you know the cause of action you brought to the court, and you know the evidence you've adduced. But then, how do you bring out this evidence? Some of us, we make the mistake of jumping to the conclusion first. So I think it should be a deduction. You make an analysis of the fact. I know I'm repeating analysis of fact because the facts are the fact. Okay? The facts are the fact. And it is your analysis of this fact and your manipulation of this fact that will enable you apply the law to them. If you don't bring them out, you'll be quoting the law thinking they apply, but the judge will not be able to see it. Okay? So you have to be able to organize your thought process in such a way that you already know the answer you want to get. So your legal submission is actually an answer to what you've said. Okay? That we contracted him to do this. He was supposed to deliver this on so date. He did not deliver it on so date. The evidence in support of this is this. We wrote to them to deliver this. They wrote to us stating that the money is no longer enough. You get that the economy has done this, the economy has done that. So that because of this, they have breached the contract. Now, you've been able to display the factual situation first and not the law first. So after you've displayed this factual situation, you will now be able to say that this happened in so and so case. That this is what the court said about this factual situation in so and so case. But by the time you've said in so and so case, the court decided this, you are basically putting the cart before the bull. Okay? So let's try as much as possible to, organize your thoughts first. Ella would tell you there was something we were taught to do in our own firm. We still do it till date, where we call it the statement of structure. Basically, you identify all the issues. You get all the pieces of evidence that has been pleaded and has been tendered in court, and then you now use these to get the issues for determination, and then lay down these pieces of evidence, and then just apply the law to it. By the time you do it that way, you will not be trying to prove that a law is correct. No, you will be using the law to show that the factual situation of your client deserves, is meritorious, and the court should actually give you judgment on it. So you do this, and then be sure to make sure, because there's an app called Grammarly. So you make sure that you review your document. So I recommend you use Grammarly for this, because Grammarly would help you eliminate several errors, the mistakes you may have made. Because along the line, as you are drafting, you could read something correctly in your head or in your mind, but that thing is not the way it is on paper, because you've seen it every time. You would forget that is there, that it is THET that you wrote down and not THAT. So maybe in the hurry, you just wrote that down. So Grammarly will help you detect this. So it is necessary that you download Grammarly and you use it to proofread your work at every time. It helps you, it saves you from the embarrassment of presenting something to somebody, and then maybe on the first page, on the very first page, you see that there are errors, repeat errors all over the whole thing. Okay, so we can move on. Networking and building relationship. I think we touched on this earlier. We touched on networking and building relationship earlier, and I told you that you have to be as social as possible. Networking etiquette. So building relationships, okay? Building relationships and getting clients is a difficult affair, except you are a very social and popular person, or maybe you came from a background that is widely connected. But building relationship and getting people to trust you is a difficult affair. First, you have to know that when that opportunity comes, you have to present every diligent work, because the work you do for Mr. A speaks to Mr. B, and Mr. B would likely decide on whether or not to consult you. So you have to build relationships with people all around. If you must succeed, it is necessary. And when doing this, a lawyer has to constantly exude confidence. Okay? You have to be confident and polite. After all, what was the worst that could happen? Because you need to earn a living. Okay? So in as much as you're not going to lower your standard, that's another thing I need to mention, that in as much as you're not going to lower your standard, but you have to be as polite as possible, be as considerate as possible in networking. Okay? Don't allow anything a client does to get to you that much, because you can always sever yourself from the relationship, but you need him to survive. Okay? Now, there is need for mentorship. If you have a mentor that you can always go to at any point in time, every time, this mentor could create a pathway for you, and it could make life a bit easier for you. There are some used briefs. Some seniors prefer the used briefs, so they could hand down the lesser ones for you to try out with, and you could, that way you can still make money as you are going. So a mentor is necessary, so that if you encounter challenges, you can easily run to him, and then your mentor will explain it for you. He could basically explain anything for you. He could basically explain and help you make corrections to things you would have done that would have been detrimental to your career. Okay, they would put you through with the practical aspects of their lives. Basically, if you have a good mentor that has been able to impart you with some of the mistakes that he has made. You learn from it, and then that way you would be able to excel. Okay. Next slide, please. The role of technology in the legal profession. Of course, technology has our research work, our drafting have all been impacted by technology. Even same contract that you would think are quite difficult to draft. You get to put it on AI Meta, and then it brings out some of the clauses that you need, and you just build on it. Okay. So technology has impacted our profession severely. And it is because of technology that we have so many other diverse areas of law. And there are new things that are coming up. And then there's need for lawyers to also protect client interest in the tech space now. Intellectual property is a very huge thing now with us. But I kind of believe that the role of technology in the legal profession should be a different topic. Metalex should try and find a way to make the role of technology a separate topic for another day, so they can be discussed in details, because technology is trying to take over our workspace. Okay. A lot of services. Technology is actually attacking a lot of service delivery now. So this needs to be taken into consideration too. But we have a lot of things that have also aided us, like the AI method that I've just mentioned. It's still because of technology that we can research easily now. So in as much as technology is attacking us, we can also gain from it. So we have to leverage on it, because the wider it grows, the more important it is for people to be there that are conversant with virtual contracts. Okay. How do we now execute all these virtual contracts? How do we properly protect the rights of our client on some of these transactions that are done without people even meeting each other? Okay. And then the issues of privacy. So lawyers are also needed in that angle too. Issues of privacy and all well not. So we have to learn and embrace technology, especially use the tools available to aid our research. I've mentioned a couple of them that are just technology based. Okay, next slide. Legal tech tools. Okay, that's what we're just about speaking on. So you have to explore and utilize some of these legal and tech tools. I just mentioned that, I tried drafting a surrogate agreement recently. It's something I've not done before. So when I tried doing it, I just said, okay, let me try this AI meta thing. And it brought out some reasonable result. And with that result, I was able to build on it and do whatsoever I want to do. So you can also use that. And you have to, I don't think there's any lawyer that wouldn't want to rely on the Law Pavilion and then the Nigerian Weekly Law Report. I think the Nigerian Weekly Law Report, they have just refurbished their entire system. So their system is now very good. They're actually giving better results at the moment. Their online reporting now is quite adequate. So you can use that. Then, so technology, digital transformation, technology is changing the way legal services are delivered. So you have to adapt your practice to it, because the people that are able to use technology more have more visibility. Okay. Like Metalex now, I think Metalex is going to be high up there very soon with the way they are going. So we have to learn this thing. We have to be as fast as possible. We are the younger generation. So your generation is younger than mine. So we have to be sure. We have to try as much as possible to leverage on technology. It is very important. Leverage on it to do the work, leverage on it to earn money. There are a lot that could happen. So you could just, you can gain expertise in maybe intellectual property protection, you can gain expertise in a particular area of tech law, and then you can use that to basically earn a living. So get these qualifications online, the fintech, I think. So you can get these qualifications online and then you use it. In fact, it gives you advantage when you're looking for jobs too. Being very conversant with technology, it gives you an added advantage. Okay. So balance work and social life. This is always a problem for lawyers. So what I suggest was stress management, because I don't think a lawyer can ever avoid coming into so much work. You will constantly be bombarded with so much work, especially as a junior. So I think the best way to do it is maybe you leverage on vacation period when the court is no longer in session, when courts are not actively in session. So you can leverage on that, and then you pray that there's no urgent matter you're handling, because if there's an urgent matter, you have to stay back like I do. So you have to learn and understand that, and no matter what, another lawyer could actually do the job. Yes, another lawyer can always take up the job and do it. So you have to be careful. You have to balance it out. Try and focus on work when you're at work. And then if you're trying to socialize, the time you're keeping for yourself, let that time be for yourself. Okay. So you can explore the vacation period and any other holidays that are made available to you. And if you are blessed enough to work in a firm where you can take leave, don't shy away from it. It is necessary so that you won't have this burnout problem. And then it's necessary for lawyers to have an hobby, can have a sport you engage in. It is very necessary. It is very necessary so that you can balance it out. And your health is also very important. So if you don't balance it out, you will end up not doing the work that you so much desire to do. Okay. So this is very necessary for your long-term success, and it also would help you avoid burnout. So you have to set clear boundaries. Try and set clear boundaries for yourself. Don't allow the whole thing can come, it can crowd you out. It has a way of choking somebody out. There are a lot of things to do, and there's so limited time to do them. So it could become a difficult situation, but you just have to set boundaries and then tackle them as they go. Okay. So like we were saying about setting boundaries, I think you have to learn to say no and prioritize. That's what I'm saying. Basically, if you're at work, okay, be at work. If you're no longer at work and you want to maybe engage in other social activities, just try. The disturbance may come, but you would only be able to do this if you are employed. If you are an employee under somebody, you would only be able to do this if you fulfill your responsibility while at work. Because if you haven't, somebody will end up calling you, and then so many things could happen. So to set boundaries, you also have to be effective in managing your time. Okay? Because you cannot leave the work of your employer. Can't leave it and then set boundary to go and enjoy yourself. No, it won't work that way. So for you to be able to set these boundaries, you have to manage your time at work well. Try and do the work you've been given on time, so that you will be able to also use the other time that is meant for your social life properly. So I think it's important to note that. Okay. All right. Let's see. All right. I think we've gone through all the slides. So if there are questions and answers, I think we can see what we can do about them now. Or if there's anything that is not clear from what I said, we can actually handle it now.
Okay. Thank you very much, Barrister Apple. Thank you so much for your insights into the legal profession. It truly is an honor and a privilege to have you here with us. So, guys, we are going to open the floor now for questions. If you have any questions regarding what Barrister Echo has said, or outside of what he has said, you can start dropping your questions, and you're free to turn on your mics if you have any question. One person at a time, please, so as to avoid um, interruptions. So we have Ede Emanuela. So Ede Emanuela, you can ask your question first. You go first. So yeah.
Good evening, sir, and good evening, ma. And it's not really it's not necessarily questions, but there were some books he mentioned that could help in like drafting. He mentioned Kelly's Draftsman. I was wondering if like it could be written down and maybe dropped on the chat box or on the WhatsApp community. So if anybody's interested to like in getting those books to assist us in whatever we are doing, we'll be able to do that. And also in regards to tech, I'm always hearing about legal databases, like database for legal, for firms and things like that. But I've never really seen like people that mention those databases in question that we should be getting, like we should like try to use now. We should try to be familiar with them right now. All I know is they are legal databases, but I don't know any specific one yet. So I was wondering if you could also tell us about that. Thank you.
Okay, so with regards to the books on drafting and contract and whatnot, Barrister Echo will communicate to me, and then I will drop it on our community page. Well, as for the legal databases, Barrister Echo, the question is
Okay.
for you.
Yeah.
So if you could
Okay.
help out there.
Like you rightly said, I will send the necessary books to you. Okay, that will help you. Now, the legal databases, legal databases. Okay, everybody says legal databases, but you know, most times I think starting out, what you really need at the moment, what you really need at the moment is the law pavilion. Okay, I don't know if the person asking has a different, because I think the law pavilion has a lot of information concerning Nigerian law, but there are other databases that some firms have, but they may be limited to just those firms. Okay, so they may be just limited to just the firms. You may not have access to it, to their own databases, but I think with in terms of research, I think what Metalex was trying to introduce you to is actually an online platform where you can do research and all that. So you can use the law pavilion and you can use the NWR. So I don't know if I'm getting your question right, but if you mean something else, then maybe I don't have any idea, but I can get back to you on it. Okay. But if in
Okay,
terms
sir.
of research, you can use the law pavilion and all that. Okay.
Okay, sir. In terms of the research, I'm sorry if I still want to ask a question. In terms of the research, I know there are legal research databases like the Law Pavilion,
Okay.
Westlaw, Nigerian Weekly Law Reports, and the rest. But like I've attended like a lot of webinars, and they're always mentioning legal databases, like databases that help in a firm for case organization and things like that. But I've
Oh,
not
oh,
heard
oh,
of
oh.
any name for anyone like
Okay.
that.
All right. If that's what you mean, there is the need for confidentiality. Okay. So because of the need for confidentiality, firms pay money and they just, set up their own database. It is not something that is left out there for the public to manipulate or for anybody to interfere with. So these firms just set it up for themselves and then they do it. It involves a lot of money. But I also get your point. There's this online database where contract and everything could be done. There's a database where people actually, a platform, I've forgotten the name. I actually attended a section on it. A platform where contract and everything could be drafted. And if you breach it, your account is directly linked to those contracts. If you breach the terms of the contract, penalties are automatically deducted from your account. I think I will check the name of that particular database. It's very common. I think most of you in the tech space could know it. Because of this virtual contract situation, those kind of databases are also there.
Thank you
Okay.
very much, Barrister Echo.
All right.
So we have other questions. So Victoria, you can ask your question now. can go ahead and
Okay. Good evening, everyone. Good evening, Mr. Echo. Thanks for that thought-provoking session. I'm really so grateful for that. Okay, so my question shortly is that you made in your session about ethics of the legal profession, you made mention of some rules and everything. So I actually want you to help me like expatiate on one particular rule of the rules of professional conduct, which is rule 15 sub 3, I think paragraph D. Yes, I know paragraph D. It is paragraph D. So please, sir, it talks about like lawyers telling the client about the alternative dispute resolution, and it's saying that that is going to lead the lawyer to a professional misconduct if the lawyer does not inform the client about it. I mean, the aim of every lawyer is to make money. So, do we mean to say that if the litigation, like if you know that, yeah, this is like you can use litigation to work it out, are we still going to suggest alternative dispute resolution to that particular issues of the clients? Or will we just, just switch to ADR or just switch to litigation? I mean, which one is it together? Do we have to place one over the other? So that's my question. I don't know whether you get it. I mean, the aim of every lawyer is to make profits. Thank you.
Okay, Barrister Echo, I think the question is for you.
Oh, thank you. Thank you so much. I was speaking. I didn't even know I was on mute. Thank you so much, Victoria. Okay. Now, you see, the legal profession is trying to make sure that the court is not so much crowded, but that the court is not so much crowded, but that we find alternative means. And you know, there are lawyers that have majored in this alternative means of dispute resolution. You also know that even this alternative means of dispute resolution, perhaps Metalex should look into it too as a topic. Arbitration is very expensive. Lawyers that thrive in arbitration make even more money than lawyers in litigation. You need to check it out too. So you're saying that you wouldn't, it would mean that lawyers don't earn money by referring a matter to ADR. It's not very true. To even pay for ADR, if you maybe put an arbitration clause in an agreement, and that agreement is not an agreement that has, that is very huge, maybe hundreds of millions, I would advise you don't put arbitration clause in them. But to go back to your question, even when you are filing a matter at the FCTI court now, or even most courts, so to say, even in Lagos, you would have to give a certificate of, pre-action counseling that, you've counseled and that you've suggested alternative dispute resolution to them. In fact, I think Lagos goes a step further to trying to make people go to their mediation center to do it. Okay. So you have to know that they're just trying. I don't think it's compulsory. It wouldn't lead to anything. You just have to advise, like this certificate of pre-action counseling. You just have to advise. After you've advised and then you file the certificate, there's nothing left for you to do. You can file your case. So it's not really an issue. And you can also decide to delve into arbitration. If somebody wants to do arbitration, it's expensive. Maybe negotiation and mediation could be less expensive, but I know that arbitration, where an award will be given that will be binding on everything, on everyone, you are going to pay a whole lot of money. I am running away from arbitration when the money involved in the transaction is very small. If the money is below 100 million, I don't think people should go to arbitration. Let them take it to court. Yes, you need to take your ADR course very seriously, Victoria. Arbitration and ADR is actually taking over. Okay. They are structuring themselves to take over. Okay, like if you don't pay these people their money complete, they're not even issuing a reward to you. If you don't pay the money to the arbitrators complete, they are not issuing a reward to your client. The award to your client. Okay. You have to pay their money complete. And these guys, they charge most times in dollars. So take arbitration very seriously. It's an angle you can really thrive in. I bet you. It's a very good angle. We did an arbitration. I wouldn't mention the name because it was kind of, we did an arbitration. I cannot mention the name. I'm not allowed to. But I know that the money the arbitrators were calling was too huge that I was like, is it not better to just go to litigation in some of these matters? Yeah, it will take time, but if the money is not huge, let's leave it alone. All right.
Okay, Victoria, I hope that answers your question. I personally, I was a part of the case, and trust me, the money was huge, and the stress is way lesser. You get, so ADR is for the soft life. You get, I have friends that are in ADR, and they are really doing well for themselves. So take your course seriously. Take you very seriously. So do we have any other question? Do we have any other question? Anyone? Any question? Okay, so I think Barrister Akpofure wants to say something about the legal databases. So I think he should come on now.
Good evening, everybody. I mean, good afternoon. Is it afternoon or evening? So, Mr. Ekwo, Barrister Ekwo, I'm very, very grateful for the fact that you took out your time to come and grace our onboarding. Personally, I think I learned a lot. Yeah? I said this internship program is not just going to be for the interns alone. Even we as lawyers will still find a way to benefit from it. So thank you very much, and thank you, Emanuela, for doing a great job. So about the lady that asked the question on legal database, I think she or wherever the information she's getting the information from, I feel they are having a confusion. So legal database is just a system where everyone can access information. So for your research, for instance, now, Law Pavilion is a legal database because it's a system that has a repository of information, data. So you want to do your research, there are cases in that system. So that's a database. So legal database is just any system that you can access a wide range of information from. So for examples like I mentioned already, your Law Pavilion is a legal database. Then you also have LexisNexis, the Nigerian Weekly Law Report that Barrister Ikwu mentioned. Yes, that's also a legal database. As a matter of fact, our Metalex platform that we're currently building on, it's also going to still serve as a legal database. So just understand that a system, whether it is used in-house or it is for the public to access, so long as it is like a box where you just go there and there you are basically sorting or seeking for information, then that's a database. That's a legal database. Don't get confused. Don't let the big English that legal database. That's just the technical aspect or the technical definition of it. It's a system that has information. So whether it's for research, you're accessing case law, statutes, and the rest, that's a legal database. So I don't know if I'm clear. I just said I should just ship it in to give further clarifications. And then during the course of the program, we're going to make a list of some of them and we'll recommend them to our interns. So thank you very much for listening to me. Yes.
Okay, thank you very much, Barrister Akpofure. So yes, I think that's the end of the session. If there are no further questions, I think that is the end of the session. However, we have one surprise announcement to make. So with regards to the first task that was assigned to the interns, Metalex Legal decided to reward those who took it seriously and who were the first to, carry out the task. So I'll be calling out four names, four individuals. However, if these individuals are not present at this meeting, they would have to forfeit their reward. I just want to put that out there. So the first person is Sistus Obiago. The second is Stephanie Ohioma Margaret Adenikpekun. I think I pronounced that well. And then Victoria Omiranti. So if you all should send a direct message to receive your reward. Yes, for a job well done. So, who is that? Who has a question? Who is that?
No, I'm saying thank you, ma.
Oh,
Thank
okay, no problem.
Thank
No
you,
problem.
Ma. I love your hair. Thank you.
Thank you very much. Thank you all for joining us.
My pleasure.